And then the light comes on.
I'll just grab yours.
Okay. It's 6 o'clock. We're going to bring the meeting to order. Shelley, could I have you do the roll, please?
And then there's going to be an echo.
Chair Emil-Hines,
Present.
Vice Chair Summerson. It's okay, I can hear you.
Present.
Ms. Strom, I'm hoping I said Ms. Hughes,
Present.
Mr. Chisholm,
Present.
Ms. Hart,
Present.
Mr. Mitchell,
Present virtually.
Councilmember Russell,
Present.
and we have staff member Carrie Babin and Jackson Higgins, Attorney's Office. Quorum is present.
Thank you. I'm going to do the approval of the minutes. Has everybody had a chance to take a look at those? Are there any questions regarding the minutes? Okay, with saying no questions, could we have a motion to approve the minutes, please?
I motion.
Okay. Seconded. All right, let's do a vote. Approval of minutes, say aye.
Aye.
Nays?
Aye.
Okay, the motion moves and the minutes have been approved. Thank you. Do we have anyone from the public who wishes to speak? Seeing none, we'll move on. Let's begin with the old business. And as we recall last time, we had a presentation by a number of the city staff regarding the chronic nuisance work that's being done, and we've requested that they come back. And we're wondering if, will you have a presentation for us, Jackson?
Yes, we have a presentation ready. Mostly will be open for discussion and questions, so very
Okay.
short presentation.
Would you like to proceed with the presentation portion?
Absolutely.
Thank you.
Good evening, everyone. Jackson Higgins, Assistant City Attorney. Tonight, we're going to go over the chronic nuisance abatement ordinance that we brought last month and had a discussion over. First, I'll very quickly review what chronic nuisance abatement is. Then we'll go over the issues that were addressed at the October meeting. And then we'll walk through the revisions that were made because of the issues addressed in the October meeting. And then you'll find later in your packet some property data that was compiled. And so I'll explain what that is, and we'll walk through that list together. So on the review side, the nuisance activity portion, there's two aspects to chronic nuisance abatement. There's defining what is nuisance, and there is defining how the city is allowed to abate those nuisances. So a reminder here, chronic nuisance combines both behavioral and physical nuisances. And so reminder, that's why there's an exhaustive list of the behavioral nuisances, the criminal conduct that constitutes a nuisance, and then all other code violations, including property maintenance and other such physical nuisances also apply, and they apply together. Generally, these are municipal code violations. Like I said, the reason we list out the behavioral nuisances is that limits us. We can't go beyond that. And there are certain protected violations that we can't enforce as a chronic nuisance, and so I'll go over that again later. Generally, the theory behind chronic nuisance abatement is that these are properties with repeated nuisances and repeated violations occurring, and that demonstrates potentially a lack of care or a lack of preventative measures. We'll go over later, it's not necessarily indicative of a lack of preventative measures or care, but the chronic nuisance ordinance is specifically drafted to address those instances. This is over a concern that some properties are hosting repeated nuisances and that they will invite further violations and dangerous conditions. On the abatement strategy side, like we mentioned last time, it's relatively open-ended, and that is meant to give the city plenty of discretion because there's a long laundry list of potential violations and combinations of violations that will require various kinds of abatements. And so the city is required to consider the responsible party's intent to self-abate. We'll go over that protection later. And their initial response to third-party nuisances on property. So one thing that was brought up last meeting was a concern of holding a business owner, for instance, liable for conduct that they're not responsible for, they weren't participating in. And so we drafted a specific protection in the ordinance that will address that. Now, the first abatement strategy that's available to the city is the abatement agreement. And that's tailored by the responsible party and the city. It's drafted together, it's approved by the city. And the city here is trying to work with the responsible party to find the best strategy possible to work with them to abate nuisances on their property. And then after that, only after that, civil action will allow the court to enter an order requiring compliance if they aren't compliant with the abatement agreement that was drafted between the parties, or if no abatement agreement was ever received by the city. And then finally, and the very last piece of this is a misdemeanor violation, and that's only considered when there's an unresponsive party who's already received a court order and is non-compliant with that court order. A quick refresher on what we talked about in October. There were concerns about the appropriate abatement response. So we talked about what is a proportionate abatement. How do we put in the ordinance, or how do we draft this so that the city can apportion its response appropriately based on the conduct that's being committed at the property. And then a part of that was this 10-day deadline for the abatement plan. Recall that when you're first in receipt of a notice that you are now a chronic nuisance property, you are given a 10-day timeline in order to give the city an appropriate abatement agreement plan. That was, someone mentioned that might be too short of a deadline for those who are actually trying to abate the nuisances on their property, and so we put in the ordinance that the city is allowed to consider the property owner's reasonability and their intent to work with the city to draft an appropriate plan, even if that goes beyond the initial 10 days. We also had some concerns about potential non-intended impacts on commercial properties and businesses. And so we talked about the different thresholds we have for what constitutes a chronic nuisance property. So I'll point those out, the specific thresholds that we came to. But we've now also separated a specific threshold for commercial properties on top of those residences that go from single residence to multi-residence to more than 10 residents. And then we talked about what is the effect on responsible business owners. Are we punishing people who are doing their best to call the appropriate enforcement agency when stuff is occurring on their property? We have a specific carve out for that now, so we're not just relying on the city's discretion. Obviously, the city is not incentivized to go after those individuals, but we wanted to make sure we codified that in the ordinance, that they're actually not allowed to, and they have to follow a specific process when reviewing what properties would fall under the ordinance and exclude those who are being vigilant and protecting behavior on their property. There was also questions about the criminal versus civil nuisances and abatement proceedings. We had a good talk with Fort Collins about why they drafted the burden of proof section in their ordinance, and we also talked with the municipal prosecutor about what that looks like in practice for us. And then we talked about what are multiple dwelling units under common ownership, so I'll address that as well. All right, this is where we'll walk through the changes to the ordinance from last time. If you want to follow along, obviously more than welcome to. In section 1, in our definitions section, we're going to look at the sliding scale that we came to for what constitutes a chronic nuisance property. And here, the average we found for a residential property, and that's a single residence, would be 3 or more nuisance activities occurring within any 90-day period, or 5 or more nuisance activities occurring within any 12-month period. And the reason this says with each activity occurring on a separate day, we found multiple examples where there was a crazy event that occurred, multiple charges were filed at a property on the same day, but it was all related to a single event. So we didn't want to have a one-off instance occur and then suddenly you're a chronic nuisance property. And then in for 2, a residential property with between 2 and 10 dwelling units under common ownership on which 4 or more nuisance activities occur, so a higher threshold within any 90-day period, or 6 or more nuisance activities occurring within a 12-month period. This 2 to 10 number comes from multiple other city examples, but to put this in mind, these aren't big apartment complexes, but they're shared units, so we understand more behavior is expected to occur on these properties, so that's why there's a higher threshold. And then a residential property with 11 or more dwelling units under common ownership on which 5 or more nuisance activities occur within a 90-day period, or 7 or more nuisance activities occurring within a 12-month period. That is the highest threshold for residential properties. That's where we'll fall, where large apartment complexes will fall under. And then what was requested at last meeting was a separate carve-out for commercial properties. This is just so that under other cities' ordinances, a commercial property doesn't have more than one dwelling unit, and so that would fall under our first section. So we put a specific carve-out with a higher threshold for commercial properties, and that's with 5 or more nuisance activities in 90 days, or 7 or more in 12 months. This similar higher thresholds are present as were last month for any property where drug-related nuisance activities were occurring, and then any abandoned property. We want to be able to expeditiously step in and abate where there's not a identifiable responsible party for abandoned property.
What's the definition of an abandoned property?
So abandoned property would be where it's not in use, not an active use, and we can't identify a single property owner. And then if you want to go down, still on the definitions section, protected incident is the definition we'll be looking at. A protected incident, and these will not count when we're accruing nuisance violations on a property for purposes of identifying chronic nuisance properties. And it's an incident occurring on or related to a property that either involves a person who is a victim of a crime at that incident, or is first reported to law enforcement or the city by an owner, property manager, tenant, occupant, or guest in a good faith request for emergency assistance. We obviously don't want to punish them. These are the people who are being vigilant, and that's not who we want to enforce under this ordinance. Or it constitutes a domestic violence against a tenant or occupant, or against a guest of a tenant or occupant. And that, again, that's a federal protection. We're required to have that in there.
So this is the formalization of the carve-outs we talked about last time?
Yes, sir.
Okay, thanks.
And there will be more later as well, but this is our first response to that. The notices stays the same. If you want to, Section A is notices, Section B is abatement by the city and costs. In Section A, that's where we have the first requirement to give notice before someone's designated a chronic nuisance property. They're one away from being designated. And then they receive notice of chronic nuisance property designation. Once that occurs, the 10-day timeline starts where the property or the responsible party is required to give the city an abatement agreement, to propose an agreement. To address the issue from last meeting in Section B, the 10-day period for submitting an abatement plan can be extended at the discretion of the city if the responsible party is deemed to have adequately demonstrated their intent to collaborate with the city on nuisance abatement. So we're not punishing anyone for taking longer than 10 days. Obviously, sometimes there are nuanced issues that will require longer to codify a good agreement.
I'm going to jump in because I think we need to kind of discuss these and kind of flesh out the questions while you're presenting, if you're okay with,
Absolutely.
with some of that. And I think number one under the notices did confuse me a little bit. And maybe you can clarify it again. Upon determining that a property is at risk of becoming a chronic nuisance property with one more recorded nuisance activity, does that mean that there's now 2 nuisance activities?
No. So
Okay.
this means that with the different sliding scales, let's say, for instance, it's a residential property, 1 dwelling unit, which would be a chronic nuisance property if 3 or more nuisance activities occur in the 90-day period. If you're at 2 within 90 days, you have noticed that if there's 1 more violation within
Okay,
that
so
time
it's
period,
1 more after the 2. Okay, just
after the 2 or after the 3,
whatever
it is,
that is. Thank you.
where
That
they're 1 more
clarifies that.
violation away from becoming a chronic nuisance property.
Okay, thank you.
Could that be worded a little bit more clear? Because that is confusing. I agree with you, the way it's worded. Can you look at that wording and?
Yeah, I can absolutely look at that.
Yeah.
Can you, just for my sake in drafting it, it reads to you as someone receives a notice if they have 1 nuisance occur on their property?
It's an awkward sentence.
And I think that it maybe needs just to be clarified by 1 more than that particular category, 1 more beyond the category threshold, or 1 more that, instead of going, in other words, kind of tie it back into those thresholds by the property sizes.
Understood?
Can I ask a question? And in all fairness, I wasn't here at the last meeting, so I guess what I'm having trouble understanding is the public going to understand this? I mean, used to, we always had notice of violation. We are totally changing everything, and they're understanding. How is all of this going to be communicated to the public? So what, and I wasn't here, so nuisance properties, and some of these words in here that we were already talking about, like, for one thing, the drug-related nuisance. Aren't certain drug-related issues criminal? Not a nuisance, a crime.
Yes, so criminal behavior is a nuisance.
Criminal behavior is a nuisance.
Yes,
So
a
are we
violation.
redrafting everything? I mean, in the current code, without changing this, is criminal behavior described as a nuisance? In the current Muni code, is criminal behavior described as a nuisance?
A nuisance is described as a violation of municipal code, and we have criminal conduct in our municipal code that is prohibited. And so violating the criminal conduct in our ordinance is a public nuisance. So it won't change how the public views a breach of municipal code.
Okay, so criminal conduct would not fall under this board, correct? Or
Or
the
code.
community development? It would fall under the police department.
Yes.
Okay. Okay. I appreciate that, so.
Okay, so
Oh, as I understand it, it's where that those criminal acts are occurring or those people are behaving. The physical location, the residence, the building, which comes under, would it come under the building?
Yes. So I think if I'm understanding the question, and you can absolutely stop me if I'm not understanding the question correctly. If there's a concern that we're creating a new violation, we're not. The violations under code are the same. What we're doing is, for the first time, being able to track. And again, if we decide this is not the way we want to go, that's absolutely okay. But being able to track behavior and physical nuisances occurring on a single property to identify if there's something going on where the responsible party isn't identifying and mitigating those issues, physical and behavioral, then the city is now able to address that concern with the responsible party.
I had problems with this last time at the last meeting, and this is improvements on it. I think and tell me if I'm wrong or right, what you're saying is when a crime is committed, it's that individual that is charged. This is covering the property and the owner of that property or the person that's in charge of that property. So it's it's based upon a crime or a violation of the code being done, but this covers stopping the behavior at that property. So it relates to the property more than the individual or the owner of the property. Am I right in that?
Yes, absolutely, yes.
Okay, if that's the case, then I have another issue. We have an example on the books where a property.
Rita, can I ask for a second? I understand you have a lot of concerns about this, but I believe that this is a board discussion, and I would encourage you to take the issues up directly with Jackson and with the attorney's office to kind of get the clarifications you need. I will certainly welcome you to bring in your opinion if you feel that it is something that severely affects the discussion that we're having. So I'm just asking that you do that. And you're welcome to.
I need to speak up on that. That's why we're here, is to discuss this and get familiar with what this is going to do. So I object to that, where this is supposed to be the discussion of this board. And I would think that is what we should be doing
This
during
board, you said it.
And within this presentation to find out what we need to know.
Okay.
This is the time to do that.
But this is a discussion among the SEAC committee, and we welcome the perspective that Councilperson Russell brings. But I don't want this to be dominated by that discussion when we have other questions that need to be answered with.
I object to that also. I don't think that's proper. That's what we're here for.
Well, I want it to be clear that this group is a citizen committee and that the discussion had is among this committee. Councilperson Russell is a liaison to council. She is not an active member of this committee. And that the discussion that happens needs to be among us because it is us who will make those decisions. Councilperson Russell also has the opportunity to speak individually with the city attorney's office to get clarification on this. And I don't believe that time taken up during the SEAC meeting for her to get clarification is an appropriate use of our time.
I disagree because
Can you turn your mic on, Edie?
disagree because I think the things that she brings forward offers a perspective that is valuable for all of us on the committee. And that enriches the discussion. So that's my opinion.
I would agree that if invited to contribute, or when invited to contribute, I think the interjection in advance of the discussion by the committee itself sometimes leads to then the committee being led by the elected official. So I think, again, that's why there's a liaison role, which is to liaison, which is that we come up with things, we seek the liaison's counsel to bring it to council. So there's a very specific role, which we can talk about during bylaws. I don't think it's well defined. So I agree that the input is valid and important, but I think that it needs to be invited in, which I think is where Rick was headed, but I let Rick speak for himself. So.
Yeah. Michael, go ahead. Can you turn your, yeah.
I agree about role and responsibility because I agree that it is courtesy for people on city council to be a liaison, which is a listener to us. They are not peers to us. We are citizens. This committee has a history. Staff people who have tried to steer the ship, and with no bad intentions, I think there's been instances where the liaison has steered the discussion. I have not been able to get a word in edgewise since this meeting started. And when the person, the liaison, is injecting questions and discussion, I'm a member of this committee. I'm waiting for my chance to speak. That is not appropriate. I think we need to talk about role and responsibility on this. This is not nasty business. Nobody's attacking anyone. But role and responsibility of this group needs to be clear in all of our minds. We need to respect everybody, but just like staff, if we ask staff a question, they answer it, it's great. But if they jump into the conversation and start influencing the direction of the conversation, that's inappropriate. This is our time. And I agree with Rick. City council people have every opportunity to talk to anybody they want on multiple occasions. So if I can segue from that as an example of what I wanted to say, and it does relate to what our bylaws are all about later. I'm confused, Jackson, and this is me, this is not your writing. When I went through this, I'm making notes to myself and I'm going, well, wait a minute. This is all attached to property, which is what Linda was saying, the same thing. So that means this does not address a behavior of somebody revving their motorcycle up in front of my house out on the street, because that's not related to my property, correct?
Correct. Yeah.
Now, the city has codes. Again, Linda's brought this up in the past. Noise abatement. The city has codes relating to noise. I was reading up and I thought, well, that's interesting. And yet I'm sitting on something called the Code Advisory Committee that has no purview, no role or responsibility to comment on one set of codes, such as the motorcyclist in front of my house. But if the motorcyclist camps out in my front yard, now the problem is attached to my property. You see what I mean? These boundaries confuse me in terms, and given the changes, I'm wondering, does this speak to what is the purview of this group? What should we be paying attention to? But in my mind, there's an artificial nature that I haven't liked in the past. When a neighbor says to me, the road rally is happening again tonight at 10 o'clock and my baby can't sleep. Aren't you on code advisory? Oh yeah, but that's not our bailiwick. And there's something inconsistent about what's a code in Englewood. And again, maybe that.
I was going to say, Mike, I think that's a very valid point, and I think that that's certainly a discussion, within this group. Would you agree that we're really focused on?
Yeah, and again, I apologize
chronic,
if I'm getting
that's
off on
okay,
a
but
tangent,
let's kind of keep this.
Yeah.
bring it back up, I think, during a discussion about bylaws.
And to the extent that I understand it's related to property, I think it's pretty good. I don't have any problem with this. But going forward, I need clarity in my mind about, I mean, is this one set of codes related to property, and are there other sets of codes in Englewood that perhaps this group should pay attention to? I'm done.
Thank you. Do we have any other questions regarding this section specifically? And I think this is kind of a key piece of what we were working on last time, was that breakdown. Do we feel that this is a better representation of what we would view as the numbers associated with nuisances rather than just the kind of an open-ended thing that was previously regarding apartments and things like that? Is there any other address to that?
Rick, this is Matt Mitchell here.
Yeah.
I just want to get some additional clarification around the distinction between criminal, right? We're talking about criminal behavior. We're talking, there's some information here regarding the frequency of that nuisance activity and a time frame. So, for example, 3 or more nuisance activities occur within a 90-day period. 5 or more nuisance activities occur within a 12-month period. So I want us to talk a little bit more about the mechanics around that. We talked about the distinction between an arrest happening, adjudication of that offense as it relates to the property owner, having kind of control or not control over that, mostly like in a renter situation. So that to me is a piece that I think is unclear to me. We haven't talked about the frequency of that. And I think this has been helpful in terms of clarifying behavior that occurs at the residence versus the condition of the residence. So I'm going to stop there and see if we can share some more commentary around that.
I think it would be, I think it's an appropriate question for you all to weigh in on in terms of what you would think is appropriate. I think you had pointed to the question of, in terms of our guidance, yes, mostly what we need from you is ultimately a recommendation for how you want to see this go forward or not go forward to City Council, but also weigh in on if you'd like us to come back to you with substantial changes, including if you think these are inappropriate scales for the number of occurrences occurring within a certain time period. And then I'd be happy to address the other piece of that question as well in terms of who we are holding responsible. Part of this is you're seeing a ordinance that's fitting into our current public nuisance scheme, and that's Title 15. Responsible party, that's why we define this not just as property owner, and this is in our definitions in Chapter 1 of Title 15, is a person who is an occupant of or has actual possession of or is the owner either alone, jointly, or severally with others of any real property or personal property. So the point is, it's not just in terms of someone who's renting the property. You're not the responsible party if there's nothing you could have done to properly mitigate the nuisance occurring on your property. So again, it's kind of a squishy definition, but it is so on purpose so that we're not holding this against property owners total. Does that make sense? Does that answer some of that question?
Renters.
I think it's helpful. Yeah, I mean the distinction between responsible party and property owner needs to be clear, and certainly when it comes down to the abatement action associated with that property, the property owner ultimately is responsible, could be responsible for the abatement action.
Edie, did you want to chime in?
There's not a question there. There's just kind of
No, we appreciate, yeah.
the back end of my statement.
Do you have a question regarding that, or how do you feel about that?
Yeah, if you have, I guess it's clarification, if there's a renter on the property, is that renter responsible if they have performed
It
all
will
of
be,
these
sorry,
things?
continue.
Or is it, let's say they have had 3 strikes on a drug charge, okay? Dealing out of the house that they rent. Okay, is that, who is the responsible party in that case?
This will be assessed on a case-by-case basis.
Okay.
So there is not a cover-all for, in that instance, we would hold the landowner responsible or the landlord responsible. It would be case-by-case, whoever is best situated to have prevented the nuisance from occurring in the first place.
So if this is an illegal action that's happening on the property, I'm assuming, and I think this is where Councilperson Russell is getting at, that's a police issue, okay? However, the fact that there was multiple occurrence of this at a specific residence, that falls under the nuisance, the chronic nuisance. Is that
Yes,
correct?
yes, and. So
Okay.
yes, and if the responsible party hasn't called the proper authorities immediately. If they call emergency authorities, as a responsible property owner would do, if criminal violations are occurring on their property, it doesn't count as a nuisance for the purposes of a chronic nuisance property. So we're not just going after properties. That's why we have this list for us to go through at the end. All of those aren't just de facto chronic nuisance properties, because most of those, the emergencies are being called and reported immediately. And so anything that's being reported immediately does not count as a nuisance for the purposes of this ordinance.
Okay, so you've got a drug dealer who's been caught 3 times dealing drugs out of the house. And it was reported not by the owner has no idea that this is going on, but reported by the neighbor.
Right, so then that would not be a protected incident. So that's what we're trying
It
to.
would be a nuisance
that would
property,
likely be a chronic nuisance.
chronic nuisance.
If it hit the threshold for that level of a property, for the amount of drug activities occurring, which for this it would be 2. I need 2 in a 30-month period. That would be a chronic nuisance property. And the purpose of that is for that property owner to be vigilant in protecting those occurrences from happening on their property, because the chronic nuisance ordinance operates under the belief that that person's best situated to prevent that from occurring. And so if they are allowing that to occur, if, like you said, if they're unaware of it, this is incentive for them to be aware of activity occurring on their property, to become vigilant property owners.
How do you feel about that?
I'm okay with it. Where does this come under? Who decides? Who's giving the notification of nuisance, and who's doing all that?
So the notice would come under code compliance. It's a complex answer. So code compliance will continue in its current capacity. Their job doesn't change, other than when it's reported and in combination of both PD records, which this also creates a responsibility for PD and code compliance to better record things occurring on property, which particularly with code compliance, we haven't had a practice of doing that. And then communicating together for how many nuisances have occurred within a certain time period. Once that threshold is hit, it is now on code compliance to give notice of chronic nuisance property designation, and then to work with the responsible party to draft an abatement agreement.
Can I ask another question? Just rolling back. I believe that this was initiated by Sean or at the request of the city
The city council
council.
asked
right?
for us to research, and it comes from, it was presented a while ago about vacant properties specifically, that failed, it didn't go forward. And so this is another version of that was asked to be researched, brought to you guys to get your opinion and then your recommendation to go ahead and bring it back to City Council.
To do that.
Before we go any further, I want to try to create something here so everybody has an opportunity to chime in. And as you've seen it on council, is that if you have something to say, go ahead and hit your button, because I can see you're green, okay? And I'll try to remember who did it first so that we get everybody to go around, because I can see us all trying to get a thought in, but, you know, that kind of thing. So let's try that and see how it goes. Linda, did you have something you've been waiting for?
Yeah, I've just got a question on the, where was it? Giving notices. So the notice would be given like on, if there's drugs involved, that notice would be given after the first time to the property owner.
Yes.
Okay, so you would find that property owner and get that to him. Okay, that's fair.
And sorry, to clarify as well, it's the same notice requirements as in our public nuisance statute already. So that part, it cites to EMC the appropriate code that gives us the requirements for proper adequate notice.
Okay, so that actually will be an asset for a property owner to know someone has had a drug violation and that there's an issue on the property.
Right.
Before it becomes really bad.
Yes.
I like that.
Mike,
Thank
go
you.
ahead.
Just clarification, Jackson. Starting to get my head around, it's related to the property. Like Edie's example, I've got a couple more. Let's say the house that's constantly under construction. Now we've got a building. So I'm a neighbor. They've been working on that house for 2 years. And they've still got tar paper on the front, and it's not moving along. I'm sure the city has some type of code or rule on that. So I call up the city and I file a complaint and say, you know, this project's never going anywhere. Terrible. So there's a clear building situation. Another example would be there's behavior on the property. And I'm thinking, now there's immediate behavior and there's historical behavior. Whether it's drug dealing or partying at 3 a.m., you're saying, well, this is going on every Friday night for the last 5 weeks. Or you're saying, this is the first time and it's just god awful. So now I'm seeing police intervening on one of those. And I'm seeing code compliance intervening on another. So there's immediacy in one example and there's a history in the other example. I'm assuming this will give the police in Englewood and the code compliance staff the leeway to figure it out for themselves. Is that a fair?
Yes, there's quite a lot of deference and room to figure out the best solutions.
So like we're scratching our heads. Was that a criminal? Is that a civil? That really isn't for us to worry about. What we worry about is, can the city of Englewood, i.e. the police department, take care of it? So am I thinking right?
I believe so, and I'm sorry. If I can, I think I'll speak to what you're saying and tell me if I'm not.
Good.
There's nothing here that changes the police's function. So let's say it's a party late at night or a drug deal. The police come and they address that specific behavior that's occurring. Where the code bit comes in is once that hits that, however many occurrences within a certain time period, allows code to come in and talk with the property owner or responsible party and say, before it actually becomes a chronic nuisance property, and then once it does become a chronic nuisance property, this stuff is occurring on your property, and we expect you to be able to either have some preventative measures or be quicker to call emergency services.
Okay. Good. Thank you.
Go ahead, Rick.
And I believe it's that the burden of responsibility then is on the city, right? So that's in terms of calling the police or whatnot, is that they would have to come and identify that the nuisance was actually a nuisance and that it occurred multiple times, right?
Correct.
The burden is on the city to prove the nuisance.
Yes, and that's under the burden of proof section of the ordinance. The same for criminal behavior and then for civil behavior. The appropriate burden of proof is on the city to establish that it actually did occur.
Let me ask you a quick question, and it has to do with the 10 days, the plan, period. That 10 days, and I think we kind of alluded to it last time, is that 10 days to make a plan, or is that 10 days to implement a plan? And if it's 10 days to make a plan, is there a timeline put on sort of the conclusion of that plan so that you know it's been resolved?
Okay, multiple answers. The 10-day period is for the responsible party to draft and send the city an abatement agreement plan. A part of that plan will be a timeline. So it's not required to be completely abated within 10 days. It's unreasonable, but it is a short timeline for us to be able to identify what responsible parties are going to be up for drafting an agreement and working with the city. After that 10 days, and if it's longer than 10 days like we added, if the property owner is workable, the city is allowed to consider that and give them more time to work on the agreement plan. But if they're not workable and it's been 10 days, then the next steps we're allowed to take for civil abatement hearings.
Is there a discussion then? Is it a back and forth once the plan's done, basically for those people to say, well, you've got a great plan here, but we can't wait 2 years for you to clean up the property kind of thing? Is that correct?
Yes.
Okay, thank you.
Yeah. One suggestion I had was when making the plan, that you develop an outline with what you expect, because what you're talking about in here is what is an acceptable plan and what is not an acceptable plan. So I think the responsible party needs to have some kind of framework in which to be able to respond to a plan. So just a brief outline or a sample of one that is acceptable
Absolutely.
that they could follow.
That makes total sense.
Go ahead, Mike.
A couple questions. Apparently, this plan puts a lot of reliance on neighbors to complain and report. So in other words, city staff drive down the street, see a property, proactive, say that's a problem. They don't have to, and there's many instances today where they don't do. So the squeaky wheel gets the grease. So the neighbor calls up and says, hey, this is a negligent property. But it's clarifying, or I'm concerned that perhaps there's too much reliance on complaining neighbors to report it. I don't know if people in Englewood understand. How do I report it? My neighborhood, there's property down there, it looks like heck, and I don't know how to report it, I don't know who to talk to, I don't know what to do, so that's a communications challenge. And then I also think neighbors should have a status report. So if I call up and say, this is awful, and the city responds, and then another neighbor says, what's going on with that? You know, are they doing anything? There ought to be some type of status report, an update that the neighbors can say, oh, okay, the city's on it, or they threw it out, it's not a case. What's the status of this situation? So I think that's important because my neighbors complain that we never know what the city's doing. So that's a communication issue. And it shouldn't be hard to answer. The status is at this stage of the process. Thank you. All I need to know. I'm done.
If a property is deemed in the process of being a chronic nuisance, I'm talking process, somewhere along the line in the process, is there public posting of the fact that that property is in that position? Or would there be public posting of it? I think that's what you're alluding to, Mike.
Okay, so two clarifying questions, I think. One, that we talked about that last meeting, how I think it's Loveland has a public database for chronic nuisance properties. My sense from the committee was that didn't seem appealing to have a list of all the properties that were chronic nuisances. But then the other clarifying question is, is your question before they become a chronic nuisance property, is that public? And the
I
processing,
think once it crosses the threshold
I see.
of becoming a public nuisance, and I think maybe I would see it as once a plan has been submitted, that there be some visual ability to be able to track it. And I think we've had this discussion with AJ too regarding issues. And I think maybe that's more of a discussion with AJ about how that would be followed up within the compliance department. I think what you're working on is sort of the framework of the how to, not the,
Sure.
yeah. But does that make sense?
I have an issue with that, in that if you're saying that because someone has gotten a notice of being a chronic nuisance property, that they'll be on a list that everybody and his brother can see. I have an issue with that, as far as that being fair and legal. So I don't like that idea.
Clarify that idea is not on the table though, right?
So maybe to clarify, if I was correct in assuming your guidance from last meeting that you did not want to pursue that.
Okay. So we were heard.
Is that, yeah, right,
in the
if that's
last
correct,
meeting, and
then
that has not,
It's
that's
not-
not made its way into here.
no.
Let's just make sure we're all on the same page. I'm okay with this too. I was just more sort of supposing what it might look like. Do we feel that the idea of a public database of some kind is an asset to this, or is a detriment to this, or is a detriment to the city? What can I get everybody's kind of pull on that?
Detriment.
I believe in the warning phase for sure it's detrimental, and I don't know once it becomes a official public abatement and taxpayer costs. And I think there's a level, but I definitely agree that for warning purposes or the process of trying to rectify through the notices the situation, I would find it to not be good to be collecting that information or having a database of those folks.
I think that's a bag of worms we don't want to get into.
I think that if there's responsibility and the homeowner is responding and working on the problem or trying to make it right, I don't think there's a problem. I think the process is working. If it reaches a point where the city has to take action after warnings, after patiently giving 10 days notice, et cetera, I have no problem with that going on. I don't see what the problem with that is, because if somebody is in violation, they've given warning, the city's tried to work with them, no one's trying to get anybody in trouble, and they're obstinate, they're not budging, then it's going, to me, that's a fact, it's a record. And I think that's only, again, back to the neighbors, what's going on with this case? Is the city doing anything or not? And I think we owe something to the responsible homeowners who want the neighborhood to be nice, don't want an abandoned building, whatever. So no, I think at some point there needs to be public, no, this is in process or action's being taken. I don't think that's unreasonable. Go ahead.
I think
Can I have
some,
an opinion?
Yeah, absolutely.
Sorry. Yeah. I'm just thinking of like what processes are already in place, similar to like a condemnation notice. So a block over, we had a house that caught fire. There's a big sign on the front of the property that says condemned. Is there a register of condemned properties around the city that's currently accessible? if there's not, isn't that kind of an extreme case of, like, that's like a nuisance property, taking that to the, like, the furthest step possible. So I think we've got to find the right balance between privacy and public visibility. I think that's obviously what we're talking about right now. I think for me, again, it comes back down to like the adjudication process. If public notice throughout the process, I'm not in favor of, because there's not a resolution. If there's been a resolution and a property has been abated or not abated, I'm in favor of there being visibility into that somewhere. I don't know, we live in a digital age, so it's going to be a digital record and it's going to be a scarlet letter for that property owner, unless there's a status associated with that abatement action. So maybe it's completed, successful, how we want to create designation if we're going to do something publicly with that property. That's my opinion.
I'm going to just say here that I think I agree that it's a sticky wicket and we don't need to put our foot in this. And I think this is going to ultimately go to council. So for us to muck this thing up too much is probably not helping the overall cause. It's like losing the war and winning the battle kind of thing. So I would recommend that we leave this completely out of this discussion at this point. It may be something that eventually can be revisited, but let's keep it. I would recommend that we do not encourage a public presentation of this anywhere at this point.
I'm sorry, could you clarify? Are you talking about no naughty lists published or no discussion of this?
That's correct. No naughty list published. Is that clear? Okay.
I also have another question. I noticed that the research was really focused using larger cities, Greeley, Fort Collins, Boulder. I don't know if Loveland was involved, probably. I'm just wondering where the impetus came from. Why now, with a city that is 40,000 people, why now? Has there been a trend, or we're seeing things that are not looking good for the city, for the future of the city, and this is a way to reel that in? I'm just wondering, what was the impetus to look at adopting nuisance codes for the city?
So we are looking to add a tool to the arsenal in code enforcement. And one thing that starts to happen, and the reason all these other cities did this as well, is you go and enforce the same code in the same place repeatedly, and you realize this isn't doing anything to stop this behavior or this physical nuisance from occurring in the first place. And so this is one way to try and address the source of the nuisance rather than addressing the behavior every time in a one-off scenario. And so it expedites the process once you become a chronic nuisance property for the city to be able to work with that property, first to identify that property as an issue, and then to be able to address the actual heart of the issue. And so there are complaints from neighbors. This is obviously, city council gets lots of calls. And so from the city perspective, to be able to enforce, we can't enforce people's complaints, just the complaints. But we can enforce something like this, where we've established that there have been actual code violations reoccurring. So you talked about the responsibility for neighbors. First, this request of responsible parties to be vigilant and responsible in maintaining their property and preventing those things from occurring. And then second, it tells neighbors who, if you're calling and complaining about these things to the city, you should do your best to document those things, because then we can do something about it. Does that help answer your question?
Clarification. It was to provide the framework within the city municipal codes that would allow further enforcement, right? Enforcement, compliance.
And compliance and buy-in from the responsible parties to try and get them in on an abatement agreement with the city, to work with the city, and not just
Because it's
punish.
in the code. You can cite the code before the intervention, correct? Before you, I
Correct.
mean, it's the reason, it's in the code.
Correct.
Okay.
Edie, I just want to comment. We are partially responsible for this because we've had discussions in the past about abandoned buildings, absentee landlords. So at some level, we contributed to the city being aware that this is an issue that ought to be looked at. So and I feel good about that. And I think it's great that from some of our conversations got through to the channels and we're seeing something in response. Just some things are positive.
Well, I think that, City Manager Lewis mentioned that right at the beginning of his presentation, that, part of the reason this came out is because we had expressed some concern about abandoned properties and how do you handle that kind of thing. And I think it goes along that an abandoned property is a nuisance. I mean, it is the definition in my mind of a nuisance in this city. So I think this is heading in the right direction. Did you have something else you wanted to add, Linda?
Nope.
Chair, if it's okay, I just want to be mindful of the time as well, just to remind you.
We kind of jumped in the middle of your presentation, Jackson. Did you have other things that you wanted to present to us that we haven't talked about yet?
I can speed through the other changes. Nothing, I think the
Thank you.
substance we've discussed. So let me go through the other things that have changed, and then we can talk about the property records that you have. All right, we talked about the 10-day period for submitting, that can be extended at the city's discretion. This safe harbor for emergency assistance and victims. We had this in a version of it. This is a little clearer, hopefully, for you, to specify that nothing here is going to be construed or applied to discourage someone from seeking emergency assistance in the first place. So we're not punishing that. The proof of nuisance activities stays the same. This is something that I would like to get your guidance on. We had talked about this misdemeanor offense, this final step in the process. So first is the abatement agreement. And the goal here is never to have to go beyond that. The goal here is to get the property owner or the responsible party bought in on working with the city and using the city's resources as well to figure out the appropriate direction for abatement. If that process fails, we have the civil abatement process, and that's already in code. That doesn't change. What does change is if the court decides to put in a court order requiring abatement of nuisance on property, if the individual who is responsible refuses to cooperate with that court order, it creates a misdemeanor offense for non-cooperation with a court order. And that's the whole function of this misdemeanor violation. So if there's any questions about that, I can take the time to go through that, but I want to stop there if that's okay.
Questions, anybody?
Yeah, I have a question. So I get a misdemeanor because I said stick it, So I get the misdemeanor. What does that mean?
So first of all, hopefully there's lots and lots of steps before that occurs. You say not just stick it, but stick it to the court after going through the adjudicative process in the court. But it's the ordinary process for being charged with a misdemeanor violation with the court. And so there's nominal penalties. Technically, for a misdemeanor offense, the maximum penalty is 364 days jail. That never occurs. Typically, we see on average 10 days deferred for the punishment that happens with a misdemeanor offense in municipal court.
I'm sorry, 10 days and you don't have to do it?
If you comply. If you
If you
become
comply.
compliant, 10 days deferred. And that's, again, that's speaking way out of turn because it would be a case-by-case basis. But to give you some context for what a misdemeanor violation typically looks like in municipal court, that's what that is.
Are we okay with the additional piece of this thing?
Jackson, you were asking for our input or opinion on that? Is that?
If you had questions or concerns
Oh,
about it.
Let me give you my opinion. You asked for it. At some point, there has to be teeth. And we talked about, are we compliance, are we enforcement? You're talking about a process. Good Lord, this is like 90 days. This is not quickie. You're in trouble. We're going to throw you in jail. This is multiple steps over a long period of time. There has to be something. And I'm speaking from experience. I lived in another community years ago. I had the world's worst neighbor. And you make these policies for the worst of the worst. That's the problem. That's why you need a policy. 1 in 100 is going to be a problem. So that's why you have to do it. But if any of you have ever lived near a problem neighbor who almost delights in thumbing their nose at the city, it's a different perspective. And I have that perspective. So I have no problem ultimately having.
Sorry, Matthew, anything from you?
No, I think I agree. I mean, I agree with Rick. There's after a fairly lengthy process, right? There's got to be teeth. A misdemeanor is, a good starting point. So there's enough runway. Again, my concern is like the frequency, and I think we'll come back to this as we have the conversation about the number of incidences at these residents that were provided. I think that's very helpful and will provide further discussion around, distinction between a commercial property like Zoe's Lounge versus the library versus some of the apartment buildings, but we'll save that conversation for later.
Okay, anyone else? I think that it's appropriate for us to take a vote as to whether we are happy with the state, the proposals as it stands now, or whether we want another round of this to ask additional questions. How do people feel about this at this point?
I feel our role is to make a recommendation. And I think chewed on this. We don't all agree on every one of these. That's healthy. I think the city has heard us. So I guess I'm comfortable with us sending some type of green light to the city. It's not perfect, but speaking for myself, I don't have major problems.
Linda, go ahead.
I like the changes that you made in it. It makes it better, and I like the explanations that you've got. I think it's a good starting point for the city council to look at it and go forward, so.
Would anyone like to make a motion?
I'll make a motion that we, can you tell me if I do this right or not?
I'm going to defer to others here.
Okay. That we approve what we have seen of this and move this on to the city council for their input and their changes, whatever they come up with.
Okay, so I'm hearing that you're making a motion that we as a committee approve moving the nuisance ordinance forward for consideration by other groups. Is that correct?
Yes.
Okay, that's the motion. We have a second.
I'll second it.
Okay, all in favor say aye.
Aye.
Aye. Anyone opposed, please say nay. Okay, the motion passes.
Thank you for your time. I appreciate it.
Thank you very much. We are on to Communication Subcommittee update. Edie or Rick, I'm sorry. Couldn't remember who's on the-
I have not heard from Madeline back, but I presume, and AJ's not here, but I presume that our magnets are in the works. And I will be at the Christmas tree lighting on December 2nd, but I need another person there because I have to leave and go to the library for a homeowners meeting that we're having, an annual homeowners. So could I have somebody help me or tag team with me on the December 2nd?
What's your, what are you going to be doing while you're there?
Just sitting at a table, hopefully passing out magnets that encourage people to call Engelfix.
Okay.
And talking about code enforcement if anybody asks.
Okay.
I'll help you.
Thank you, Mike.
Okay.
All right.
You got to just give me the time and the place.
Okay.
Okay.
Yeah, I will.
All right.
Okay, thank you very much. Thanks for doing that. Any other communications updates of any kind?
No.
Okay.
Not really. Other than I communicated to her that
Madeline?
people like the communications plan.
Okay, good. Okay, let's go on to Grass and Weeds Subcommittee. And there's going to be a discussion about this in a little bit. I think Rick has some thoughts on it. But can we get an update either from Matthew or from Linda regarding anything in addition to what we've already done? I don't know that there is, but go ahead. Okay.
Nothing to report. No, I believe we presented our final recommendation.
Okay, very
and
good.
that language was approved and published in the last minutes.
And I did reach out, I believe it was to Vicky, and I think she said that they were in the process and they should have something back to us in January, if I recall. Does that sound right, Jackson?
It does. I will check with her on timeline, but she also said to mention that because there is definitions in Title 16, P and Z, planning and zoning, will have to be looped in as well, because any changes to Title 16, P and Z has to approve.
Okay, very good. Thank you. Well, let's keep moving. I do want to get through this. We have 47 minutes. And let's jump right into the bylaws. Hopefully everybody had a chance to review them. And what I'd like to do is I'd like to make a couple general statements, and hopefully you approve with them of them. They're kind of basic stuff, but then we can kind of go into the specifics. First of all, I would propose that we change the word enforcement throughout this document to the word compliance. Okay, I think that rather than jumping piece to piece to doing that, any place I believe that the word possibly police department is mentioned, that we insert the word community development. Does that sound correct? Okay, and I think that it'll make sense. There may be some, I think one of the questions I did have about this is it references an officer in this. Are code compliance officers, Carrie?
They are sworn officers.
They are. Okay,
Yes.
I just want to make sure that
Yep.
we can leave that wording in there. Okay, very good. Okay, let's start at the beginning with Article 1 and the mission. Any questions, any comments in the, let's just go by page, page 4, which is the beginning of this. Are there any changes, anything anybody has any questions about?
I'm looking at section 3 purpose. Am I in the right place?
Yep, go ahead.
Okay. This is pure question. I don't have an answer, but it's pure question. Given the reorganization, I wonder about the role and the responsibility of this. So, for example, when I read that, it says regulatory processes established within these sections of Englewood Municipal Code enforced by the Code Enforcement Unit of the Police Department. Now, just a question in my mind, confusion. Are we entering into a realm where heretofore we paid attention to code enforcement staff? Are we entering into a realm, pay attention or listen to or speak to the police in general? Because in the last discussion, we could see how it toggled back, police here, code enforcement there. Again, I'm wondering, I'm not advocating for anything, just wondering in the new order, does our purview expand? Or do we need to really define boundaries more clearly so that we don't take on the universe? I'm just a little confused on what's expected of us and what we want to be expected of us. Because you start taking away code enforcement, make it compliance, and that merges into policing activities, it's confusing.
I think those are good questions. I'm going to direct this back over to either Jackson or Carrie for this.
So, you sure I can at first and you
Go
can
ahead, yeah.
clean up? So your purpose is laid out in code, and your purpose is specifically to regularly review the activities, services, and regulatory processes established within those sections of the Englewood Municipal Code enforced by the community, and it will be compliance unit, and it will be of the Community Development Department, and to provide recommendations to the City Council for updates and modifications to those services and regulatory processes. So insofar as you're serving that purpose, it's specifically related to code compliance, which does not include any of police department's activity.
That's accurate. So again, even with the merger reorganization, the enforcement capabilities and limitations, rights, all that remain the same. So we haven't increased any duties, nor have we decreased any duties. We simply moved one group to a different department. That is it. There are no other changes.
Okay. Real world example. Not trying to be difficult.
No.
I'm just confused. So in my research, I think Linda has brought it up, and maybe Edie, I know I brought it up. Noise. Noise in Englewood. Motorcycles, trucks, etc. And heretofore, that's not our business. That's on the streets. It's not code enforcement. But I find out in chapter 2, under, there's a declaration policy 621, and holy cow, Englewood has a whole bunch of codes relating to noise, defining noise, what's proper. Come to find out, you're not allowed to make a lot of noise with your truck. You're not allowed. I didn't even know it existed until I looked it up. That's fine. But I can tell you, I have not been satisfied that Englewood enforces this, because I have motor rallies in front of my house on a regular basis. So then I'm thinking, this is a code. We need to keep our nose out of it. In other words, who who does for this type of code what we're supposed to do for our types of code?
Yeah, so the metering of noise actually does fall under code compliance as well. But police can also meter that noise as well. Have you been submitting complaints or anything about noise? You can call non-emergency police department, you can put in a Q alert, or you can reach out to code compliance directly. Good,
I
yeah.
got it. Let me give you another real world example. Cherokees. For the last 2 years, we have had demonstration of Cholo cars going up and down our street, revving their engines. You can talk to anybody in our neighborhood. Me and my neighbors have called the police department on numerous occasions. We've had different answers at different times. The old police chief told my wife, there's nothing we can do about it. She looked at the city code and she said, oh yes, you can, they need a permit. Then I find out there is reference to a permit. Who approves the permit? So the last time it happened, we called up and the police department said, oh, they got a permit. Well, that means they're doing their road rally. They're going down by where the Halloween thing is, there around the circle. And so the neighbors are sitting there watching this noisy thing go along at 10 o'clock at night. And the word is the city gave them permission. All I'm trying to point out is the confusion. It is not clear who's on first base. It is not clear who's accountable. It is not clear who gives permission to do a road rally. They certainly don't run it by the neighbors. There's opportunity for improvement here. Don't take this as all negative. Are we going to be involved in an opportunity for improvement? Or is it not our bailiwick? We should assume somebody else in Englewood is going to look into it. Again, not trying to be a pain, but there's room for improvement here. And when my neighbors say to me, well, aren't you on code enforcement? Yeah, but I don't have anything to do with that. That doesn't make sense to me. I'm done.
Want to address, I guess I'm going to jump in a little bit on this. I think that our purview is defined by what you see here under these ordinances. Okay, that's what we're being asked by council to address. I think your issue is well taken, Michael. I think that can probably be taken up to someone in community development, someone in the police department. I'm with you on this. I just don't know if it's us that we have to, yeah, okay. All right.
I've been recognized.
Yeah, you're fine.
Great. I think for me, what I would be curious about as we think about the bylaws, and I think to your point about where part of bringing code compliance into community development was there's a lot of synergy between a lot of other code or a lot of other compliance things that are happening that maybe weren't happening by compliance officers. And so I do think there likely needs to be a call out of that collaboration, or where, like we heard from Jackson earlier, that there's a planning and zoning thing that we provided some feedback on a section that now has to go to somebody else. We don't know who those people are technically, right? So I think just more clarity around, I think we're going to run into those issues more often. And I don't necessarily know if it needs to move into our purview or whose purview it is, as Michael shared, but I do think we need to figure out how to call attention to that in a more deliberate fashion so that we know where there is opportunity to participate or collaborate with other folks who are handling all the codes that are around all of the codes that are called out in section 2 of our creation, right? So I think it's going to become more important to identify where that overlap is, and then have the committees, advisory, whatever, work together on that overlap where appropriate and where needed.
Okay, thank you, Rick. Let's keep moving here. Anything else on the first page? Okay, let's jump over.
Yeah.
Oh, go ahead,
Right,
Matthew.
I just want to say, I mean, I think, right, section 3 is very clear what our role is. I think we've debated that today. We get narrowed on section 4 into the specific sections relevant to the provisions of Title 15 that roll up under the umbrella for our debate. The question that I've got on Section 4 is, are there any additional titles or sections that need to be expanded based on what we're currently debating? I think if we look at the specifics, if we're talking about amending the powers and duties that are outside of regulating domesticated animal welfare and control, non-domesticated animal control, environmental pollution, graffiti, noise, outdoor storage, snow and ice, removal, trash and litter, grass and weeds, trees and shrubs, and wood burning. The task at hand is to determine, are those updated? Should they be expanded or contracted? And if they are, what are we recommending? As it relates to Section 4, I think that moving, that's our task at hand right now.
Okay, that's a really excellent question. I believe, and this is only from the experience that I've had on here and the fact that we have consistently gone through the municipal codes now for almost a year, I guess, that I don't see that anything is substantively changed in terms of the description of those things. And I guess I'm going to once again bounce it back to Carrie to say, Carrie, do you envision our purposes being any different than what is written here already? Because some of that is a decision that's beyond our group.
Yeah, I don't see the purpose of this board or the board's functions being any different than what it is now. We can take a look at the wording of that first or the second sentence in there that talks about environmental pollution, graffiti, noise, outdoor storage, and possibly expand upon that based on the collaboration between different departments. We can do that.
I think that would be appropriate.
Sure.
Yeah, we'd appreciate that.
Yep.
A very good point, Matthew. I think we're into new territory here. We've been functioning under something for years now, and now with the change, it may have an effect on what it is that we are responsible for and the ultimate ask that you have of this committee. So thank you. Anything else?
Yes. We definitely need to define what we're responsible for in the noise area. Because Inglewood the last few years has been ridiculous with the amount of revving cars, revving motorcycles. I can go outside at 1 and 2 o'clock in the morning and hear motorcycles blaring up and down. It's either Broadway, it's not Logan, so it's got to be Broadway, and then the streets beside. I can hear them clear over from Hamden. I'm kind of halfway in between. Somebody needs to take responsibility for the noise. Either this committee, as citizens, we need to do it, or we need to find out what committee is responsible for noise. This says noise, Title 6, Chapter 2. So something needs to be defined on that, because that really is ruining a lot of the enjoyment of the city that I've had. I've lived here 35 years. I've never seen it like this. And it is really frustrating when I can hear the motorcycles and the cars revving up inside my house. When I have my television on, I can still hear them. So someone needs to take responsibility for that, either us or another committee, and we need to find out who it is.
625 is very complete that way. And we did review that, and I even highlighted racing events in that section. So this is, based on what I see here, basically our purview. And I think that if this committee agrees, and perhaps we can take a look at this at a future meeting, and to say, do we want to make a statement that says everything I'm hearing now, woefully underaddressed, significant, in my mind, chronic, okay? So maybe what we can do is put that toward that. How do we feel about that?
I think that's fine, but are we recommending who enforces it?
Code
We're just-
compliance. Go ahead, let me answer Edie first here, I think. Code compliance is responsible for addressing noise. It's clear. It's part of the group that, we are the advisory committee. It's not us. It's the code compliance division. So if we feel that the code compliance division is not acting aggressively enough on this, then that's the kind of recommendation we can make as a citizen committee. Go ahead, Matt.
I was going to say the exact same thing. Our job is to review the activities, services, and regulatory processes and make recommendations.
Thank you. We're down to half an hour, and I want to make sure we get this done. Let's move on. Is there any, I'm looking now at page 5, or my pages are different than yours. I'm using a different copy.
I had some additional questions on section 4, outside of, moving into section 4B, where there is, previously review the processes, procedures, and administrative functions of the code enforcement unit of the police department. I'm not sure I've seen those policies or procedures or what the expectation here in terms of being able to provide feedback to the city manager, but I do wonder if that might also lead to some of where this noise confusion has been, right? If we don't feel the processes, procedures, and administrative functions of the enforcement or now compliance unit are properly enforcing all parts of the municipal code that we oversee or provide recommendations on, sorry. I just wanted, that one surprised me because I didn't know that was a thing that we were even supposed to be taking a look at. And so I think if it is in fact, and it does remain here, I would just like more information provided in order for us to be able to effectively do that job. And I think that could lead to some things like understanding and strengthening noise. If we feel that the compliance officers don't have what they need in that space, how do we enforce that? Or again, making recommendations or whatever the thing right below a recommendation might be in order to have our voices heard around permitting and other things. Hopefully no one's getting a permit to do a parade at 10 o'clock at night. Otherwise, I'd like to know, again, who that person is, who's approving that. And so that was my question on section, or statement / question on section B is this something we should be doing? And if so, let's make sure we're doing it and that we have the materials we need to do that. And then on section D, my question was just around the delivery of our recommendations, no less than annually. So wanting to make sure that we are in compliance with our compliance and that we are making sure that we are delivering recommendations on a regular cadence. And I did wonder whether it would be best to be thinking about, do we do them ad hoc? Do we do them quarterly? I want to do them in a cadence in which they're taken, our recommendations are taken seriously and are taken to account for the work that we're putting in and the feedback that we're collecting. And so just wanted to just kind of toss that one out as some food for thought as we continue to go through these sections. So.
One of the reasons that I came up with, doing this was because I read through this and I saw how many things we weren't doing. And I think that those are things which we were asked to do, and it's particularly even an annual report. We've never done an annual report that I'm aware of. But I do think that one of the things that this committee can do is set into motion a regular process, either quarterly, whatever we, I think, want to do that way to make sure that our information is being fed to the people who need to hear it on a regular basis. So I'm with you on that, Rick, and I think that's a recommendation that we can make for ourselves to do in a sense. Michael?
Ditto. I agree with everything you just said. We really should put something in writing formally to City Council. These discussions have some pretty powerful bullet points. Even if it's just bullet points, you need to pay attention to this. We feel strongly this. And Rick, your first question of should we be thinking about noise. If you go back up to section 4, under A, it says, we should review other chapters of the municipal code intended to prevent or abate situations that are deemed detrimental to the health, safety, and welfare of the community. Now, to me, that's a bridge, and that's an invitation for us to speak to the matter or make recommendations. Those recommendations, again, could be bullet points that go to city council. But I think, yeah, if we need to put a spotlight on a problem, I see that as our responsibility. So I'm very comfortable going that way.
Go ahead, Rick.
Are we able to deliver updates to city council, right? I know our purview is to deliver recommendations, but could we do some sort of a cadence of updates that would be delivered to city council in terms of, again, there may not be things that rise to the occasion of needing to make a formal recommendation on a change of code, but there may be some things that we're seeing as a committee that we would want to make sure the council was aware, that then again may allow for them to make a request of us to be involved in a particular way.
Terrible answer for you. I would need to do some research on that and get back to you. But I also think this might be an opportunity to kind of start creating some consistency in bylaws that align with other boards as well. That way the public has a clear expectation of what they can get from boards throughout Inglewood. So that may be something that staff can take a look at it and make some suggestions maybe for you guys to think about or not. But I can definitely follow up with you, with the board on that as well.
If you would, that'd be great. The other thing I think that I would add to this is that we have a council liaison, and that council liaison is a listening board. It listens both ways. Listens to what the council wishes, has the wishes on, and we've heard Rita say a number of times they're looking at this, so you might see something like this come down. So that's kind of our communication from that direction, but we can also use that council liaison to send things up. And if we feel that there is something, almost every council meeting has a section specifically for committees and boards to have their opportunity to speak through their council liaison. So I don't know that I've heard that and use it very much at all, but I think that it could be used, and perhaps in this context.
I think you're on the right path with that. I just didn't want to commit to that answer yet until I knew for sure, but I think that you're going down the right road as far as that responsibility goes.
Thank you. Anything else?
Rick, I would
Go ahead,
also
Matt.
say, I mean, it's clear that our minutes are published, right? And so that's a vehicle for dissemination of information from this committee. Making some assumptions that the minutes that are published are reviewed by city council members, but I do like the idea of alignment, consistency, and at some point, some type of summary of total recommendations made to city council by this committee. And, you know, that can be kind of a running total that we just, you know, our goal the last couple of years, right, has been to get through the bundle of work to update the municipal code. And once we're done with that, right, I feel like we're kind of at the end of that project. We've got a great opportunity to do some strategic planning around what this committee should be focused on for the remainder of the year and next year.
Thank you. I echo that. I think that we have an opportunity where we're seeing the docket clear a little bit after the first of the year, that we might want to be a little bit more proactive toward what we want to do. And I would encourage Carrie to get some information on how that aligns with the other boards and commissions. But if we could do that, that would help us to kind of get a roadmap of where we would be heading with that. I think that's a great idea. And I'm going to comment quickly on letter D. Committee shall act as a conduit of communication between city council manager and the community. So we do have a responsibility to reach out and communicate with the community. I think we've started something very good this year, which is, you know, a proactive communications group. And we're certainly more visible than we ever have been. So hopefully we can continue that. And I think there's opportunities for education here that we haven't taken advantage of. I think we could actually put programming together if we wanted to and actually educate people around things such as grass and weed ordinances, such as, whatever it is we decide to do. But that's under our purview to do. Move on. Anything on section 5 of the general stuff there? I don't see anything of mine that I would feel that we need to change. I think it's pretty clear here. Rick, did you want to add something?
I think it's just again, reading D, when a committee member is present at a city council meeting and addresses the city council on a matter, it feels like it takes too long to get to the point of that, right? I think it could just be tightened up to basically be like if someone is there to speak for SEAC, like, because some of us may go to city council and speak to them for other matters. So I just think looking at sentence around just provides stronger clarity on section D.
Yeah, I think you're right. The other part I think is, and I'm probably more guilty of this than some of you because I do speak before council occasionally, is to have a disclaimer when you speak with them that if you are on a committee or board or something, that you state very clearly that you're not speaking on behalf of that group. And that should be kind of SOP for everybody who speaks before council, but I'm not sure that anybody really does it.
I want to ask a question. Is there a requirement that the committee be only this big?
Yes, there is. We will get to that. It's in the sections. Basically, it says that actually it's in right at the beginning where they talk about it being reduced from 11 to 7 at some point. It's in the creation section there. Ordinance 2000-09 to reduce the number of members from 11 to 7. So we are designated as a 7-member committee.
I think that limits our ability for outreach. So, I mean, we have difficulty right now. We can't staff or get people to go to all the neighborhood meetings. And that's a pretty key part of outreach in this community. I mean, we have paper and pencil outreach, but we don't have a lot of physical or representative outreach.
And we are a small committee relative to some of the committees. We're a very small committee. How do other people on the committee feel about that? The size of our committee?
I think the size, since I've been back on this committee, I don't know how many we had before, when I was on it before, but I think the size is good. It seems to be a workable group, and someone wants to put input that's not on the committee, they've got that opportunity. But sometimes you can get a committee too big, and then it becomes an issue. And so far, what I've seen with this committee, it works very good with this size.
Anybody else?
My comment would just be in relation to the population of Inglewood. So is there just like a standard formula that would be representative of the population? So for a city of X equals X amount of representatives on the committee as a standard way to look at committees as a whole. But I do agree. I think I'm in favor of a smaller committee. I think we can get things done faster. Being fairly new to the committee, I think thoroughness and speed is important, quality, but I think getting stuff done is also really important as well for local government, speeding up the process.
Thank you, Matt. Mike, did you have a comment? Okay. Any others?
I think we have spent some time this year talking about outreach and how that might look different and how to expand on the work that had been done previously successfully. So I think in terms of planning for that and thinking about that, not necessarily by number of members, but by being intentional and ahead of the game starting in 2026 or working through it, I think we can help to address some of that. We won't all always be able to be everywhere. And maybe we don't need to be, but let's talk about that at some point and how we can be intentional. So
Anyone else on the size thing? If we wanted to do something, we probably would need to make a recommendation to council to make that change, because that's their decision, not ours. Okay? Well, we can have this discussion later too. This is not the beginning and the end of this discussion, so. What's that?
it is the beginning. It's not.
It's the beginning, not the end. Thank you. I'm sorry. Let's move on to Article 2 membership. And I think we mentioned about the change from police to community development in B. I would like to have further clarification on C as to the function of the city council liaison. And I would open to what we feel that the function of that liaison is relative to this committee. And I open the floor. Anybody want to add that?
Do we? You mentioned other groups that have bylaws that may have been updated more recently. Is there that addressed? Most of the organization or committees have a liaison.
Yeah, they have liaisons. I don't know if their function is clearly defined in the bylaws or not. That's something we need to look into.
I think I'd be interested in knowing whether there's other further clarifications. And I have some ideas that I will present, but I don't want to be definitive, and I want everybody to participate.
If they're not defined, this would be the appropriate time for this board to express what their view of that function is. That way staff can take it into account. Word it accordingly and get it put in bylaws for your review, but that's something that you guys would need to sort through.
Michael?
It's a sticky wicket because I've seen this committee get stronger and more effective. And I started when I think it was fairly weak. So there were needs in the past for staff and or the liaison to grab the microphone and to initiate structure. That was a function of how weak it was. And all those were well intentioned. So I'm not saying that was wrong. I'm saying in a vacuum, something has to fill it up. I think our meetings are healthy, right? And it's hard. You don't want to hurt people's feelings. That's the bottom. Feelings get hurt. But the fact of the matter is, my understanding, whether it's this committee, I was on sustainability, the liaison's job is to listen and to chime in when invited to chime in. Rita's done a great job when we said, what's going on? Why is council doing that? I think that's totally appropriate. But when we're debating, like we were tonight, about our role and responsibility or noise or whatever, that council person is not a member. And they should listen to the dialogue. We can invite them into the dialogue if we choose. But for any of them to just jump in as if they're a member, I think is a bad habit. Put it that way. And that bad habit started for all the best reasons. But I think as we have to evaluate our role and responsibility, I think council has to evaluate its role and responsibility, as staff does. What is my role in this meeting? And frankly, this is our meeting, and this issue has come up over the last 3 years on this group. Whose meeting is it? Is really what we're saying. It is the citizens committee, not the city council's meeting, and it's not staff's. So I think we need to pay attention and try not to hurt feelings, and that's easier said than done. It's tough when feelings get involved, but we need to be sensitive to that. But the bottom line is, this is our meeting.
Thank you. Go ahead, Linda.
I think tonight, since Rita wasn't here when we were discussing this the first time, and I know how panicked I was when I saw the first draft of this thing, all she was trying to do was get some questions answered. And I do not think the response back to her was fair or respectful of her position. And I think there needs to be some respect for that city council liaison. And if they have questions on what's going on so they can understand the issues and understand what we're doing, if there's some confusion there, and I think she was starting to understand when all this happened, I don't think that was fair or respectful for her. So there is a fine line there to be covered. No, she's not part of this committee as a member of the committee, but we also need to respect her as being a city council member and her questions and her concerns, because she was very concerned about the direction this was going, and I was very much so the last time. This is a much better draft than the last one. So I think we need to keep that in mind when we deal with whoever is sitting as that liaison to the committee.
Thank you. I do agree that the council member had specific questions, and I recognize that. One of the responsibilities that every committee person here has, as well as everyone who sits at this table, is to be prepared for the discussion that comes up. Rita was not here last week or last month. She was not privy to this discussion. And she had every right to ask specific questions. What I heard was not just questions. It was anger, it was outrage, it was inappropriate to the discussion we were having. I felt the questions she had would have been directed better to people on staff, and if she had hopefully read the information and reviewed the meeting from last week, she would have been up to speed a little bit more. And it's unfortunate. She's been very busy, and I recognize that. However, that's the reason why I took the position that I did. I stand behind it as the chair of this committee, and I believe that I will reach out to her and apologize for the way in which I did it, which was inappropriate.
I would offer one comment as well. I think it's a matter of the rules of procedure, right? And finding the right time to acknowledge the liaison and offer an opportunity to engage with the committee. And I think that, in the cadence of what transpired tonight, maybe it was premature to allow comment until we had finished our debate. Again, it's revisionist in terms of can't change what happened, but I think maybe moving forward from a meeting cadence standpoint, we can be sensitive around the procedural rules for allowing commentary and figuring out how that can better allow us to get through our deliberations and then allow engagement from liaisons.
That was one of the reasons I have asked that this committee consider clarifying Section 1C regarding the liaison's role within this group, is that if we have this within our bylaws, then I think that it's clear what everyone's role is in a sense, not just hers, but the role of each committee member in this. And I'm going to leave it at that because we're really pushing on time. Where are we at on this? Do we want to continue with this discussion to finalize the bylaws, or do we want to table this for the next meeting? We don't have to get this all done. It's not under a timeline thing. I know it needs to be done. Where are we at on that?
You said something about you were going to get us something of kind of a template.
More suggestions on ways that the bylaws can be edited to align with the rest of the boards as well. We can do that for you.
Okay. Suggest maybe that we wait for that.
The only thing I wanted to add on Section 1, Part C, aside from the conversation we just had around a particular circumstance and a particular person, I want to remove both of those things and come back to 1C to say that I do think that we can provide clarity here with what the Citizens Committee has assumed to be the expectations of the council liaison, regardless of who that person is, so that it is clear for them, it is clear for us. And as I shared before, I think that, and Linda just asked for the comparisons, right? I don't want to put something in here that somebody else has already done, or somebody else has not done, or somebody else has chosen not to do for a particular reason. So I do think that 1C needs to be addressed. But I do think we need more guidance if it has been addressed or how other folks might handle it. But I do think we need to add some clarity here on what that role is intended to do and how to best serve us and us best serve them, since again, we have been appointed by the council to provide them recommendations, right? So there is a two-way street with whoever sits in that seat.
Yeah, for the sake of clarity too, I do want to make certain that the board understands that if that role has not been clearly defined, again, you guys need to be prepared to propose what you would like to see in those bylaws. I will gladly supply you, our staff will gladly supply you with everything that we have for your consideration, of course. We are not steering this ship. This is your determination to make. We just want to make sure you are armed with that knowledge.
Yeah, I agree with that. I think the one thing that I think it would be good to see something in writing. And so I do think that we should propose what would it look like if we did provide some guardrails to the city council liaison and the expectations we have and they have. And I think we value the input. I do think the input needs to be invited. And so I do think if there can be some iteration of taking that into consideration on 1C, that would be helpful to sort of see what that might look like and how that feels, which I think, again, is what Michael had already shared too, right? There is some inherent humanness to all of this. And so I do think it would be good to see what that might look like in writing so that we can further define, refine, clarify, or pull back.
Thank you. Are we in agreement then that we are going to pick this up next time? Are we okay with that? And get some clarification from Carrie regarding other ways that this has been addressed. I appreciate that. That being said, I recommend that we forego the statistics report. I don't know. I looked it over. AJ's not here anyway. It doesn't look like there's anything particularly pressing. Did anybody have anything that they saw within the statistics? Nope. Okay, if that's the case, I think we will just wait until we see statistics at the next meeting. Is there anything else anybody else would like to bring in? It's member choice time, Michael.
Just to state the obvious, and it ties into this conversation, our agenda always has council members' choice. Isn't that an opportunity for the liaison to throw their 2 cents in to participate at the end of the meeting. In other words, there's a formal block of time for them to have microphone. And maybe that's something we should take more seriously, is we expect to hear from them. We want to hear from them when we get to that point on the, so.
I think that's a very, very good observation, and I think that if you can keep that in mind when we come back to this,
Right.
that we could probably integrate that within the role definition of the council member.
I think when a presentation is being made, I know when I'm listening to someone presenting something on a subject, I want to ask the question during the discussion so that my question is relevant to what is being discussed at that time, and that person, I know, and all the other people in the meeting know what I'm asking the question on. I don't want to wait an hour, hour and a half to ask a question that may have been already addressed or the people have left that I want to ask the question to. So yes, that end time is their period to present something or if additional questions, but I think they need to be part of asking questions on a discussion and asking questions on a presentation. Just so they understand it and we understand the questions. They, you know, a city council person may have input that we don't have their view, and what we're doing is to be sent to the city council. So that's important, I think, to get their input and be part of it.
I completely agree that the council person has an absolute right to ask questions, just as anybody else does, as long as they are recognized by the chair, just like everybody else is. And I think, again, that's a piece of this. I understand what you're saying, Linda, and I think that their opinion about it, there's a fine line there between asking a question about it and having an opinion about it.
Yep.
When they
And that can be
become
judgmental.
when they have an opinion about it, they kind of blur that line between the membership and not the membership of this committee. So that's my concern with that.
Just to clarify what Linda just said, if we're deliberating, at any point in time, can't any of us turn to the liaison and say, what's your opinion? Or, which is different than that person injecting themselves into the deliberation. I've asked at different times, what's council think of that? Or what's the ruling on that? Or where does that stand? So I think, Linda, that exists. The difference is, if you simply turn to the liaison and say, what's your 2 cents or what's your thought, that's okay. That's legal. On the other hand, for the liaison to jump into the conversation without the invitation, it sounds petty, but no, that's the rule. You know, you when you're invited in, join us. If not, sit back and listen to the deliberation.
I'm going to call time here. But I do want to ask a real quick question. Typically, and I mentioned this, I think, in my note out to all of you, is that the December meeting, and I believe the city is taking sort of the month off for committees and boards. Is that what I heard?
I will have to reach out and ask because I have not heard about that.
Okay. So the possibility is that we could, and again, that's what I heard. So I was encouraged to maybe see if we want to cancel the meeting. Our voice of experience on the committee speaks. I would recommend that we take December off because of holidays. It is close to a holiday. Some people will be traveling. We might have difficulty finding the quorum. How do you feel about that?
Yes.
Matthew, out there in the ethosphere?
I'm fine with it. Yeah, we did discuss this at the last November meeting, that there was going to be a hiatus in December, so I'm in favor of it. So.
Okay. All right, then I'm going to say that our next meeting is going to be in January then. And if anybody else has anything else they wish to add at this point, otherwise this meeting is dismissed. Thank you.
Thank you.